Welcome to the Attorney Post, your source for inside baseball talk about the legal field with the top attorneys in the country. Here's your host, Justin West.
All right, and we're live. Hello and welcome to the Attorney Post, where we discuss inside baseball talk in the legal field with top attorneys of the day. I am incredibly excited today. I've got Kevin Mayer with me here, and we're going to be talking about all of the ins and outs of all of the things he does over at Norton Fulbright, which is a huge law office. They have like 4,000 attorneys there. And so I'm really excited to introduce you guys to Kevin here in a minute. But first, we do have a word from our sponsor. So I'm going to jump over to our sponsor screen. And there we go. Our first sponsor today is injuryattorneyleads.com. Personal injury attorneys spend a lot of time and money on advertising, but it's difficult to get qualified leads. You're paying for leads that are usually not qualified, or worse, you're getting leads from the internet that are no longer interested in talking to a lawyer if you are ever even able to get a hold of them in the first place. These leads can average between $99 on the low end and over $400 on the high end, and you can burn through 5 to 10 of these leads just to get one prospective serious client on the phone. The solution is injuryattorneyleads.com. Injuryattorneyleads.com will live transfer people directly to your law firm who have been in an accident and who want to speak to an attorney about their case. You can be sure that these potential clients meet all of your criteria for a qualified lead, and the close rates average around 60%. Sign up for a time to speak with a client generation specialist today by visiting injuryattorneyleads.com. Again, visit injuryattorneyleads.com. All right. And now I've got with me Kevin, and I've got one heck of a write-up about you. I'm just going to kind of read the highlights here, Kevin. Kevin is a partner at Norton Rose Fulbright, which is Los Angeles and San Francisco, has offices in both Los Angeles and San Francisco. He has litigated and tried cases in multiple federal and state and territorial and tribal courts, as well as before government agencies and administrative bodies. His exceptional skills in the courtroom is evidenced by his role as a counsel of record in some of the most important appellate decisions of tort litigation defense over the last 25 years. Kevin also has an active counseling practice. He represents clients facing regulatory enforcement at both the state and federal level. He's frequently represented clients in the oil and chemical arenas, sporting goods, fitness, cannabis, CBD, energy, medicine, medical devices, industrial and consumer products, manufacturing, and so on. He has a lot of experience addressing complex scientific, medical, regulatory, technical issues. All of these are important. They play very pivotal importance to the various companies that he works with in what he's doing. So he just has a litany of stuff. I saw a couple of things I want to jump out right here. It's the California Safe Water and Drinking Toxic Environment Act, which was Proposition 65. You were a big part of that. You were also part of the TSCA, which is the Toxic Substance Control Act as well. And just a whole litany of stuff. So Kevin, I'm sure I missed a ton of things there. What I miss?
Well, first of all, Justin, it's great to be with you today, and thanks so much for having this opportunity for me to chat with you. I am first and foremost a trial attorney, and over the course of my 36 years of practice, that's really what I've emphasized. The vast majority of my trial experience has been in the area of product liability, toxic tort, and OSHA litigation. Toxic tort more or less being a shorthand for cases that involve claims where people contend that they were exposed to chemicals, either in industrial or consumer grade products, and that those chemicals ended up causing cancer or birth defects, reproductive consequences, and systemic disease. The OSHA work that I have done over the majority of my career has involved everything from compliance counseling to workplace internal audits to incident investigations. And then on those occasions when either the state or federal OSHA entities have issued citations against the companies for violations, we would come in, appeal those citations, and litigate, and if necessary, try those matters before administrative law judges. So as I say, first and foremost, I'm a trial attorney, and those are the areas in which I've practiced. The regulatory aspects of my practice have dealt with, as you mentioned, California Proposition 65, which is the Safe Drinking and Toxic Water Act of 1986. Some matters under the Toxic Substances Control Act, and other federal and state regulatory schemes.
Wow. It's a lot of proverbial pies that you got your fingers in. So what would you say is, if you had to boil things down, what facet of the law do you feel most at home in? What's your favorite area to work in, or favorite kind of work to be doing?
There's no question that it would be in the area of product liability. That has been the dominant theme throughout the majority of my career. And it's always been a very fascinating area because this is an area in which we are dealing with a particular theory of law called strict liability, that is liability without fault. And this is a public policy determination where the law has decided that we will hold manufacturers, distributors, retailers of products that are found to have a defect of some nature and which cause injury liable without having to demonstrate that they were actually negligent or behaved in some improper way in either manufacturing or designing or warning about the product. So it tends to be an area where those of us on the defense have the deck stacked against us a little bit when we're litigating and trying these cases, but nonetheless, an area where we've had some pretty good success on behalf of American industry and manufacturers and have done our jobs. You know, when we go to trial, we fully expect to have an opportunity to win those cases. Otherwise, we wouldn't do it. Right. And fortunately, our clients are quite committed to the process, and they're committed to the belief that we have in their case, as well as the belief they have in their own products. And so that gives us a real good position to be in when we go into the courtroom and want to tell our story to the jury.
All right. Well, I know you've represented a lot of big companies, a lot of companies people would understand, people would know and are very familiar with. And one that's very topical and timely, I just stumbled across while I was doing some pre-show research, and I thought it was absolutely fascinating. So I'd love to talk about this. You represented 3M, which is, we all know them. They make the tape and they make the sticky stuff, the Post-it notes and all these things, but they also make N95 masks, which of course, as of about a year ago, became very in vogue for some totally random reason that nobody knows anything about, right? All of a sudden, people just like to wear them around. I don't understand why that is. But it sounds like you were fighting to do a couple different things. You were fighting to prevent damaged goods and maybe even counterfeit goods from hitting the market that were representing 3M in a bad light because they weren't legitimate or they were damaged. You were also preventing people from raising the prices unnecessarily from price gouging. So tell us about that whole situation. How did that come about? What was the problem? How did they reach out to you? What was the resolution? Is it ongoing, et cetera? Because it's just fascinating and very timely.
Well, as most of us who are, by virtue of being alive during the course of the pandemic are well aware, we have a mandate in many places, although that's coming off now in certain states, to wear masks in order to protect not only ourselves, but others around us from inhalational exposure to the COVID-19 virus. And at the time that the pandemic took off and really began to accelerate, 3M, which is one of the world's great suppliers of personal protective equipment, was the manufacturer and is the manufacturer of N95 respirators. And this is a particular type of respirator, which is considered to be quite effective against preventing exposure to COVID-19 and other sorts of airborne pathogens that may be out there. What we found was happening, and what the company determined very quickly, were that people, of course, were taking advantage of the crisis that was being presented by the pandemic. And so we saw two things happening. One is that manufacturers in various parts of the world, Asia and elsewhere, were counterfeiting the 3M N95 respirators. And then secondarily, people here in the United States were engaged in price gouging. 3M itself typically charges a very reasonable price, somewhere between, say, $1.15, $1.35 for each one of these respirators. But it got to the point where various entities were charging 10 times that amount or more for a single mask. And so this was in violation of both federal and state law, which prevents or outlaw, if you will, this sort of price gouging from going on. So 3M reached out to us and a number of its other preferred law firms around the country and asked if we would assist them in going after the price gougers and the counterfeiters. And so we did that. And as a law firm, we sent cease and desist letters. We filed lawsuits where it was necessary. And we ended up successfully resolving all of those things, in essence, putting these people out of business, going after their supply chain so that we could arrest the development of these counterfeit products and stop the fraud that was being perpetrated on the consumers.
Gotcha. Now, I have a question about price gouging, and it's just probably from a lack of knowledge or lack of understanding. We all learn in basic economics, you have your supply and your demand, and obviously we had a low supply and a very high demand, and that will always naturally drive the price up in the market. So how do you, from a legal perspective, differentiate between just the natural price raising because of the increased demand and the scarcity versus actual price gouging?
It's an excellent question. And you're right. This is a situation that does not follow the law of supply and demand because, once again, when these laws against price gouging were passed, it was determined to be as a matter of public policy that these sorts of essential products could not be subjected to the normal course of the laws of economics. So what do I mean by that? The law prevents someone from charging more than 10% over the typical price that would be associated with that product because we don't want people to profit unnecessarily and unreasonably during the time of a crisis. And that was particularly true here, where we found that people were not only price gouging, but they were claiming to have access to hundreds of thousands, if not millions, of masks, which they actually never had access to. And so not only were they charging people in advance a premium price for a product, they didn't have the product to provide. And so this was a classic example of what these federal and state laws were designed to prevent.
Okay. Yeah, when the whole pandemic hit, I remember my wife actually purchased, I think they were one of those varieties of masks from Amazon, and they took like 3 months to get here. When they finally came, it was like clearly like a knockoff made in China, and she sent them back and whatnot. So clearly this was something that affected everybody in a lot of ways. I find that just utterly fascinating. I would love to dig into the facets of the law even a lot more at some point, just because I'm a free market guy at my heart, right? And so some part of me is like, well, how far is too far, or how do we prevent these laws from overreaching and preventing people from just I mean, there's something to be said for the natural ability to profit in an opportune situation, but also there's a balance point between not harming people through your means. Obviously, if they're selling counterfeit products, if they're defrauding people, if they're selling damaged products, they don't have what they're representing that they're having, and they're scamming people. That's a very, very different thing. But the whole price gouging thing is just I find it fascinating. I find it hard to wrap my head around. So,
well, the thing that people need to understand about that is it wasn't 3M that was making any excess money. They had made a conscious decision as a company, as a good public citizen, that they were going to continue to sell their respirators and make them available to where they could do the most good in the healthcare industry, to first responders, to the elderly, to people that really needed to have them. And they weren't going to increase their price regardless of the increased demand. So the people that were actually committing the price gouging were people that had nothing to do in most instances with 3M. They were middlemen that came out of the woodwork. Nobody had ever heard of them. They were not distributors for 3M. They weren't authorized to have, much less get access to these products. And so those were the bad actors that we were going after.
And did you happen to represent Charmin as well? Because I noticed that toilet paper became very hard to get a hold of as well.
No, we did not. I think toilet paper tended to fall into a different category from respirators.
I don't know. I think it's equally necessary, but
I wouldn't dispute that.
So let's stay on COVID for a minute, only because I know that you've actually had your hand in helping a lot of businesses understand the ramifications of COVID. You've been a part of you've been a speaker, you've been a moderator for a number of events and webinars talking about how COVID is affecting us. That was as early, I think I saw in March of last year was the first time that you had begun doing these, and you've done like 5 or 6 at least, if I saw correctly. How did that come about? What kind of thing? Who are you reaching out to? Who are you talking to? Is this like big brands like your 3Ms? Is this your local mom and pop shop? What sort of things did you talk about? How did that change over the course of the various webinars that you did?
Well, as I mentioned early on, my principal specialty in the law for many, many years has been in the field of toxic torts. So that is an area that is heavily involved with medicine and science. And so when we're dealing with a virus like COVID, that falls right into the wheelhouse of things that I've addressed historically. And so when I came on board at Norton Rose Fulbright, it was literally on the very eve of the pandemic. In fact, I joined the firm about 2 weeks before the lockdowns first began in the United States. We quickly realized what was going to happen and how this was going to affect our clients and their businesses and their own customers and clients. And so we started putting on a series of webinars where we would be bringing our clients up to speed literally every 3 or 4 weeks about developments that were going on both at the federal level and in the various states where we have offices and in which our clients operate. And so I was called upon to constantly update the folks about what was happening with the Occupational Safety and Health Administration in terms of the guidance that they were issuing, often in conjunction with the Centers for Disease Control and other national and international health agencies, so that we could educate people as to how to protect themselves, how to provide a safe and healthful work environment for their employees, how to protect their customers and consumers. And so we did this for various audiences. We have within our firm something that we call our healthcare headlight. It's one of the principal areas of practice in our law firm. And so we were presenting to our healthcare clients, which could include anything from clinics to hospitals to universities to academic institutions and so forth, about these issues. And then we expanded it to our broader client base. And we presented a series of webinars across time addressing, again, OSHA and other government agency regulations, guidance documents, standards that pertain to how COVID should be addressed in the workplace. Indeed, most recently, we made presentations to a variety of trade associations and their membership, automotive companies, the sporting goods industry, healthcare, and so forth, where we would talk about these things and bring them up to date as to what was going on. And now, of course, that we're emerging from the pandemic, it's very important for these people to know how to operate a safe and healthy work environment and to deal with the ramifications of COVID, even as vaccinations increase, and we hope to establish herd immunity in this country shortly.
Gotcha. So what sort of advice would you give to a company today if you were put on a webinar right after this call we're having here? What kind of advice would you give to a company, whether they were just a local California company or whether they were a national entity, with dealing with the changes and the changes in mandates and everything else?
So the first thing that they have to look at is what are the regulations in their particular jurisdiction, both at the state level and at the county level. So for example, in California enacted what we call an emergency temporary standard through the California Occupational Safety and Health Administration, which tells employers in various types of workplaces what they must do in order to protect their employees and those who come into their premises from COVID. In addition, the county health departments in virtually every county in the country have enacted their own regulations, their own standards, their own guidance for various types of employments. Indeed, if you go on to their websites, you will often see that they have different kinds of guidance for as many different kinds of occupations and industries as you can imagine. And that makes sense because if you're running a meatpacking plant, you're going to be dealing with things different than you would in a hospital emergency room. And so the first thing we would say is get yourself familiar with what your state and your county are requiring that you do in your workplace. If you're dealing with a state or a jurisdiction that follows federal law, and there are many of them that do, then we look to the federal OSHA standards and guidances that have been issued in how to deal with COVID in the workplace.
Gotcha. How has COVID affected you personally? You said that you started right as the coterminus really with the coming of the pandemic. They tell you, hey, come on into the office, and like 2 weeks later, like, hey, stop coming into the office. Or do you do most of your stuff via telecommuting now, or how has it affected you personally?
Well, today, for example, I'm speaking to you from my home office, and I have a blank white wall behind me, which has been my company for really the better part of the past year. This has been the most unusual year of my practice. Indeed, for the vast majority of the last 30 plus years, I have spent a great deal of time on the road, sometimes as often as once per week. I will be somewhere around the country, if not in Canada, if not in Europe, addressing our clients' needs. And so when we went into this lockdown mode and all travel ceased and we weren't going anywhere, I've spent most of the time working from here on the laptop and with the cell phone at my side and making things happen in a different way from what I'm used to. So it certainly has not started out the way that we anticipated when Norton Rose Fulbright recruited me to come here to be a trial attorney in what we call our products, pharma, medical device, and mass tort group. We haven't really had an opportunity to get out there and press the flesh with our clients and my partners in our other offices around the United States. And we're looking forward to making that happen as we acquire our herd immunity and can get back out on the road a little bit. So this has been quite a different year for me, but we're making the most of it.
And none of your clients know that you're actually in pajama pants. Is that correct? Or
we joke about that. There have been times when I've had the coat and tie on and a pair of athletic shorts and my cross trainer shoes on and whatnot. But since they cut me off above the waist, we don't have to worry about it.
Just don't accidentally tip the laptop down, right? I just got through talking. I was interviewing somebody else for the podcast about an hour and a half ago. He's out in California as well. Actually, he does family law, and he's just like, we're going to look back in 2030. We're going to look back at 2020, and it's going to be the year that revolutionized the law and the way that we practice, because now all of a sudden people are Skyping it. Like he has a practice that's based just out of, I think, Los Angeles, and all of a sudden, like, he's got people in Sacramento. He's actually opened him up to the whole state because he can go anywhere if everyone is doing digital presentations, as long as he knows, the requisite rules. And he's got one of the largest divorce practices or family law practices out there. I just think it's fascinating. So do you think it's going to change the way corporate law happens as well for the most part, or is that all going to be more the same?
It's interesting. There is going to be, without question, a change in the way people do things on a day-to-day basis. I think this is going to happen at both the litigation level with the courts as well as at the corporate level. I don't think there will be as many in-person meetings as there used to be. I think courts will be happy to adopt video conferencing and other technologies that they are using to conduct hearings. We already know that people are gravitating more toward video depositions than they might otherwise. I will tell you that from that perspective, I am very old school about these things. I really want to be in the presence of the people that I'm dealing with. That's the trial attorney in me. I don't want to do things on video. I want to be with my witnesses. I want to be with my clients. If I'm cross-examining someone else, be they the adverse party or an expert witness, I want to be there in their presence, interacting with them, working with the evidence, working with the documents. I will never be a supporter of these so-called remote trials. I think the trial in our civil system of justice is one of the unique animals in the entire world. And there's a reason that it is unique, and there's a reason that it has worked so well in this country for well over 250 years. And that's because of the ability to be in person with the jury, with the court, with the parties, with the witnesses, and present your case. And I am not one that will ever voluntarily sacrifice that if I can avoid it.
That makes a lot of sense. And I'm even now, I've thought, I talk to attorneys all the time. And so I've considered the ramifications here and there, but even now I'm imagining, the future of a Zoom trial, and you've got like your panel of, it's really difficult to read the room and understand the jury and how they're feeling. I would imagine, I guess in one sense, you'd always have their faces in front of you if they Zoom it correctly and you've got them like, put into place, but the body language is gone. The ability to feel the room, read the room, and just get a sense for that would be, I feel like there would be something that would be missing.
Justin,
a poverty.
You're absolutely right. It absolutely would be missing. I always hearken back to some trial experiences I've had where I'm sitting there at the counsel table, and let's say my opponent is examining a witness, and I have the opportunity to look at the judge to see how the judge is reacting. I can look into the jury box and see how individual jurors are reacting. There have been any number of times when individual jurors have caught my eye or I have caught theirs, and we sort of look at each other knowingly, without communicating verbally what we think is going on. And you don't have any of that.
Yeah, you can't do the eye contact
in court. You have to be able to live the atmospherics of what is going on moment to moment in that trial in order to handle it properly.
That's fascinating. And that's something, even as I do these podcasts, obviously if somebody's just listening to the audio version, which you put out, that's totally different. You're just having a conversation, be like being on the phone, but it is still, even though I can see you and you can see me, we're not seeing each other. Like you can't look me in the eye in a real sense. We can't past that knowing glance. And I not, as somebody who is on the computer all the time, as somebody who does videos all the time, as somebody who's podcasts all the time, even still, like, I don't think the reality of that has really sunk in. But I think especially in an area that is as hits as close to home as the law does. I mean, that's one of the most important facets of our society. You know, to miss out on that or to lose that, I think would be a poverty. So
it really would.
We'll see where that goes.
Part of it that we can't ignore is that it's very easy to tune out when you're in these things. I know that all of us being on these Zoom calls, particularly if there's a lot of people on Zoom calls, it's very easy to pick up your phone and just put it in front of you, pretend like you're still paying attention while you're actually responding to emails, texting with your spouse, dealing with your kids' school issues, etc.
Hang on, I almost have the high score.
Doing this, but you tuned out. And those things can happen. And there's no question in my mind that goes on in remote trials. I have heard the stories from my colleagues that have had to do them. I know what's happening, and I don't want any part of it.
We'll see where that goes. I think it's brought a lot of positive changes too, obviously. I think it speeds up a lot of communication in general. I think even for some pretrial stuff, maybe it makes a lot of sense to move towards a more digital realm. But yeah, I think for the trial stuff in particular, keeping it as live as possible probably makes the most sense. So, well, let me jump to a different topic here. I had a question for you. And I stumbled over this in the intro because I couldn't find that. It's a big, long line. It was the California Safe Water Drinking and Toxic Enforcement Act of 1986, which came out when I was like 5 or 6. Proposition 65, we can call it for shorthand. Is that the reason why everything tells me that it's been known to cause cancer in the state of California, or is that something totally unrelated?
You've hit the nail on the head. So
you're the guy.
Yeah, I am the guy. The Safe Drinking Water and Toxic Enforcement Act of 1986 was a law that came about because of California's unique voter initiative system. You know, we actually can pass laws in the state of California by putting a measure on the ballot and the electorate votes on it up or down. That's how we've enacted quite a number of laws. And this particular law was enacted based on the proposition that if passed, it would protect product consumers and citizens in general in California from being exposed to quote unquote toxic chemicals. Now, that sounds like a very laudable goal. In fact, it is predicated on I will use the term, massive fraud. Proposition 65 is really not a public health initiative at all. Instead, it is a right to know about exposure. And the way it works is that the state of California, through the so-called Office of Environmental Health Hazard Assessment, has developed a list. And that list right now has over 900 chemicals, substances, materials, and exposure scenarios, which are quote unquote known to the state to cause cancer or to cause reproductive or other types of developmental harm, or both. And the standard for getting on that list is feather light, often as little as 1 or 2 positive experimental animal studies. And so it is by no means agreed in the mainstream medical and scientific community that certain of these materials have actually been demonstrated to pose a real risk of harm to humans, particularly in the circumstances in which humans might be exposed to them. Even if it might cause something at extraordinarily high doses in an experimental animal, a rat, a mouse.
Right.
It doesn't mean that that's going to happen to humans who are exposed at levels that are orders of magnitude less. But Proposition 65 isn't concerned about that. Instead, it mandates that a warning be given if an exposure to one of the listed substances could be in excess of the threshold. And the threshold that is established is orders of magnitude below any level that is even hypothetically thought as potentially causing an increased risk of harm to a human being. So what's the consequence of that? The consequence is that these warnings are everywhere. They are ubiquitous in California. They are on airport jetways, in the grocery store, at the gas station, hotel lobbies, parking garages, at the gas pump. They are on many, many, many products. As a result, they really don't have much effect. People's conduct is not modified one iota in the state of California.
Mhm.
But what has arisen in the state is a cottage industry of these private bounty hunters, because the law allows private individuals to step into the shoes of a public enforcer, like the Attorney General's office, like the District Attorney's office, and bring claims against product manufacturers, distributors, retailers, premises owners, et cetera, if they believe that they should be providing a warning about exposure and they have not. So the low-hanging fruit there is for them to walk into a store, any store, buy a product off the shelf, doesn't have a warning on it, send it off to the lab, boom, identify the presence of one of the substances on the Prop 65 list, and then send the manufacturer, distributor, retailer a 60-day notice, which is the statutory prerequisite to actually filing a lawsuit for a violation of Prop 65. So as a result, the vast majority of these cases are settled because it's much more cost effective to resolve those without litigating. Litigation is very expensive. And in Prop 65 land, the defendants, the manufacturers, have the burden of proving that they did not violate Proposition 65, either because one is not being exposed at a level that requires a warning, or that they did provide a warning and it was adequate. So that's a very, very expensive proposition if you're going to take that on and have to go to trial and win. It's much less expensive to settle and to agree to either reduce or eliminate the presence of the offending chemical, or to put a warning on the product and then pay the plaintiff's attorney's fees and a civil penalty associated with the alleged violation.
So as one of these bounty hunters, what would prevent somebody, and I'm sure that there's something in the law that would prevent this from happening, but if you run a company and I find one of your products and I send you the 6-day notice and we settle, I'm sure you're going to take some steps to prevent things in the future. That's one of the agreements of the settlement, I guess. But is there anything that would prevent somebody else from doing the exact same thing again? Or is there kind of a double jeopardy rule in play there? Or what prevents people from, having a list of, hey, here's all of these companies, I've bought their products and had them tested, I know that you can sue them, so here's your gravy train? What prevents that from happening?
Right. So in Proposition 65, there are two ways that you can resolve a claim. You can either have a consent judgment, which is a stipulated settlement, and then you present it to a court and the court blesses it. In that circumstance, the resolution is on behalf of the people of the state of California. It is entered onto the judgment rolls of the court and becomes enforceable by the court. And it's also on the California Attorney General's Proposition 65 website. And because that consent judgment was entered on behalf of the people of the state, that bars anybody else from coming back against that company for the same claim for the same products. The other way you can resolve it is in a private settlement agreement. Now, such a settlement in that situation is only with the plaintiff itself, the non-governmental organization, the bounty hunter, and their attorneys. So it is not on behalf of the people of the state of California. Nonetheless, that private settlement must still be submitted to and approved by the California Attorney General's office and will still appear on the website. So as a practical matter, because that information is a matter of public record and is available to everybody, typically, if you've settled a case, you're not going to have somebody else coming after you for the same product, for the same chemical, for the same claim.
Gotcha. It's a new facet of law. It's one I don't really know a whole lot about, but I encounter that work all the time. I bought a pack of playing cards not that long ago at a gas station for $3, and I live in Kansas, and they were shiny. They were like solid gold, contained like 0.002% real gold or whatever. And first thing I see when I pull it out is these playing cards contain chemicals that are known to cause cancer to the state of California. And I guess a funny follow-up question is the list of things that isn't known to cause cancer longer or shorter? Would it be cheaper and more cost effective to label the things that are not known to cause cancer?
It's a fascinating question. And here's the reality of the situation. This is what we talk to juries about all the time, because jurors naturally have a tendency to fear chemicals that they don't understand, and they don't appreciate what can happen. So there's two things that we try to teach jurors about this. Number one, and just generally speaking, we live in a very hostile environment. The Earth is a hostile environment, not as hostile as Mars, not as hostile as being on the moon where there's no atmosphere, but still a hostile environment. And what people need to understand is we as human beings, just by virtue of being alive, are exposed every day, dermally, inhalationally, ingestionally, to scores and scores of chemicals which are carcinogens. They can cause cancer, or reproductive toxins, or endocrine disruptors. But that's not where the analysis ends, because if that were true, the human race would have been wiped out a long time ago. The dose makes the poison.
Yeah.
That is the principal tenet of the science of toxicology, the science of poisons. So it's not just about the concept of exposure, it's about the concept of dose. How much actually gets into and remains in and metabolizes within the body. The dose makes the poison. Best example I can give you is aspirin. If you have a headache and you take one aspirin, your headache might go away. If you take two aspirin, it should probably definitely go away. If you take the whole bottle, you may go into a coma and you may die. Why? Because you have received an excessive dose, more than the body is able to process prophylactically. Pharmacology, from a pharmacology perspective for treatment, now you have actually poisoned yourself.
Yeah. There was a story a while ago, without getting too off topic. There was a radio program that they were back when the Nintendo Wii was a thing, and it was a hold your Wii for a Wii program. And they had a single mother come in with a bunch of other people, and they basically made them drink a bottle of water like every 10 minutes. And whoever could go the longest without having to go to the bathroom would win the Wii. Well, she wound up going into a coma and dying from water poisoning. Yes. So literally you can even the most basic thing, your body's made up of 70 to 90% of water. And even that can be toxic, which is just fascinating.
You know, it actually reminds me of an analogy that we use in trial when we talk to the jury about this concept of exposure and dose. And we talk to them about one of the most deadly substances known to mankind, dihydrogen monoxide. Dihydrogen monoxide, what's that? H2O, water. If a pregnant woman drinks too much water, she can actually miscarry her fetus. In the example that you gave, if you drink too much water, you can cause swelling of the brain and death. That's an example of the dose making the poison.
Well, not to mention, as we all know, dihydrogen monoxide has been found in every single patient that's died from cancer, and it's linked to all suicides. It's linked to car accidents. I mean, it's just everywhere. And yet they pipe it into our children's schools. Can you believe that? Fight dihydrogen monoxide, people. It's the killer. I was going to have a second question about that. I went off topic because I had to make a joke, and shoot, there we go. Well, that's just fascinating though. And it was related. The point I was going to make was related to the dosage question. It may come back to me. If it doesn't, I'm not going to worry about it. But I feel like I was going to ask you one more follow-up, because I think that whole discussion is just absolutely fascinating. And I mean, all of this stuff is fascinating, to be sure. So why don't we let's switch feet again here. I don't want to take up too much of your time. You've already been very generous with the amount of time we've had here. What would you say, in the many years you've been practicing law, what are the cases that really stand out to you? The cases that were the most difficult, maybe, the cases that you learned the most from? You know, what case would you say was your biggest success or your biggest failure?
So there's any number of ways I can answer that, because every trial is new and different and involves a variety of different things. I could talk about the very first toxic tort trial I was involved in back in the late 1980s with a partner of mine at my first law firm, which was an extraordinary learning experience because I had never really been involved in anything like that before. And I could talk about the what we call the Lockheed Worker Coordinated Judicial Proceedings here in Los Angeles, which is one of the reasons I was brought down to Los Angeles from San Francisco back in the late 1990s, was to help one of my partners at the firm I was at that time try a series of these cases involving current and former Lockheed employees who had worked in the top secret skunk works, the so-called black world of Lockheed, where they built top secret military aircraft. And when they closed the Burbank plant in order to move up to Palmdale, California, these workers who were dissatisfied with how they were being treated by Lockheed decided to claim that all of their exposures to all of the various chemical products that went into building airplanes had caused them to develop everything from hangnail to every form of cancer that you could imagine, and a variety of neurological symptoms, respiratory disease, liver disease, kidney disease, you name it. There's just a whole panoply of things. And so we were involved in trying a whole series of plaintiff cases over the course of many, many years. But probably one that really stands out as a success is one that I was not even designated to try. I was at a law firm which was representing a company in asbestos litigation. And I was asked to come over to provide expert guidance on how to try toxic tort cases and to get involved in those things. And almost immediately after I had come over to that firm, one of my partners had started a trial against a very significant plaintiff adversary in a very important case. And about midway through the trial, midway through the plaintiff's case, my partner got ill and was not able to continue. And so the managing partner of the firm came to me, and I remember it because we were on a retreat at the time, said, "Can you step in and finish trying this case?" And I said, "Sure, why not?" So that was on a Saturday, and Monday morning I was in court, and we continued the trial and picked up where things had left off. And we ended up finishing up the plaintiff's case, putting on our case, and we then received a defense verdict from the jury within about 6 hours of deliberation. So that was extremely gratifying.
Yeah.
And the part that I remember most fondly was I was told by a number of the jurors when we interviewed them after the verdict that they were calling me Simon Says in the jury room, because whatever I said, the judge went along with. If I objected to a question, my objection was sustained. If I made an argument in court that they had the opportunity to watch, the judge went my way. So that was an extraordinary lesson, how important our credibility is, how important it is to be trusted by the jury when you're in trial.
Kevin says, bang the gavel. Kevin says, overrule. That's awesome. Well, I'll tell you what, here in a minute, I don't want to keep you too long, so maybe we'll wrap this up in a minute. Here I'm going to ask Kevin one of those fun open-ended questions. I just want to pick his brain a little bit and see who are the three people that are most influential to him in his life. Maybe the people that encouraged him to get into law, people he looked up to as he was practicing law, or just people in general who stand out as beacons of moral virtue. Before we do that, though, I am going to jump over and read one more word from one of our sponsors, if I can get my mouse to actually work correctly here with the old Zoom. There we go. So we're going to jump right over here. And this, incidentally, what you're seeing is the law firm's website, Norton, Rose, and Fulbright. This is Kevin's law firm. However, we are going to learn about Rocket SEO from hundreds of customers. Rocket SEO. Are you a business owner who knows that being on page one of Google is important, but you're afraid to work with an SEO company because you know that SEO is both expensive and slow? Well, not anymore. Rocket SEO from hundreds of customers forces you to page one of Google safely and legally through the power of the news media. National media campaigns rank instantly. They boost your website's ranking and performance in Google in 1 week or less, and they'll rank oftentimes 2, 3, or even 4 times on page one of Google for multiple keyword phrases. Because we're leveraging the power of major media companies and network affiliates like ABC, NBC, CBS, and Fox to rank you locally and across the country. If you're interested, visit hundredsofcustomers.com/rocket to learn more about Rocket SEO. That's hundreds of customers, all spelled out, hundredsofcustomers.com/rocket. All righty. And let me come back over here so we can see you. All right. So, Kevin, we'll start wrapping this up here a little bit. Again, I know it's probably middle afternoon for you. It's getting close to dinner time here. But who would you say are the three people who've been most influential to you in your journey?
So I could talk about people that have been inspiring, but I interpret your question as a little different. Who had the most direct impact on me and what I did? And so I would say easily my father would be number one. My partner, Chris Larange, would be number 2. And then another one of my partners, Larry Jansen, would be number 3. My father was Judge Francis W. Mayer of the San Francisco Superior Court. He was the third of 3 boys. His father died of a stroke when my father was 15 during the Great Depression. My dad went to college. In those days, you only had to go to college for 2 years before you went to professional school. So he went to the University of California, Berkeley, and after 2 years went to University of California, Hastings College of the Law. Graduated from law school in 1941, right into the United States Army Air Corps during World War II, where he was in for the duration and flying P-51 fighters off the RAF fighter bases in southern England, and then was in the Army of Occupation in Germany after the surrender. Came back to the United States, clerked for the Court of Appeal in the state of California, joined the District Attorney's Office in San Francisco in 1947, and continued in that role, becoming the chief assistant in charge of major trials and capital trials in San Francisco for many years. In 1969, then Governor Reagan appointed him to the San Francisco bench, and he served on that bench, including 2 terms as presiding judge before his retirement in 1985, and then became a private judge and continued in that role for another 10 years. As the oldest of his 3 children, he was clearly the greatest influence on me, and the one that did 2 things. One, he talked me out of going into the military, not once but twice, because his view was he had done it during wartime, and at the time I would have gone and it would have been peacetime, and he didn't think that would have been productive. But secondly, he really thought that my skill set would be best used in the law and as a trial attorney. And it turned out that he was quite providentially correct about that. Chris Larange was the man that I grew up in under the toxic tort practice. I was a second-year associate in San Francisco at my first firm when he lateraled over from where he had been for a number of years. And the managing partner of the firm came to me and said, "Hey, we've got this guy coming in. He's got a toxic tort practice. He needs a bright young associate. Are you interested?" And of course, I knew nothing about this whatsoever, but I said, "Sure." And it turned out that that was probably one of the smartest moves I've ever made in my life. Chris and I hit it off instantly. We were 2 completely different people. He was a United States Marine recon platoon commander in Vietnam, had come from a career military family. And he was like the older brother that I never had, and I was like the younger brother that he never had. And we literally had that kind of relationship. And to this day, he remains one of my best friends and certainly my closest colleague in the law. And then finally, Larry Jansen, who was the head of our practice group at the firm that Chris and I started in San Francisco for him back in 1994. He is the attorney that brought me down to Southern California, kicking and screaming in 1997. Originally, I was only supposed to be there for 6 months, but Larry told me that the future of my practice in toxic tort litigation depended on people understanding that I was affiliated with him and that group. We then went on after I came down to depart the firm where he had been a partner for 33 years and started the Los Angeles office for Steptoe and Johnson, where I spent another 10 years. And then after Larry had retired, I moved on to another law firm. But those 3 people, without question, are the ones that provided me with the greatest amount of inspiration, with experience, with training, and with a real belief in me as a person as well as an attorney.
All right. I love to hear that. I just love to hear the people that influence everybody. I think it's a great question. I think people always pick, sometimes they'll pick, family, sometimes they pick friends, sometimes they pick historical figures and whatnot. But I always just find it fascinating. We are in an increasingly digital world. We're all still very interconnected, and our lives are impacted by so many people that we are physically in contact with so often. So, well, this has been the Attorney Post, and I've been talking with Kevin Mayer of Norton Rose and Fulbright out there in California, and it has been one heck of a conversation. Going into this, I did not realize that he was one of the guys that is at least vaguely responsible or had a part to play in those silly little labels that we have on everything. Obviously, you weren't involved. It's not your fault, but you had a part to play in all of that moved forward, which I thought was fascinating. And obviously, all the stuff that has to do with COVID and everything else, absolutely fascinating as well. So I just want to say thank you again, Kevin, very much for being here on the Attorney Post. It's been great getting to meet you. And do you have any final words or parting advice for our listeners?
No, I very much appreciate the opportunity again, Justin. I would simply say to everybody, I'm happy that all of us have come through this pandemic, hopefully in one piece, that we'll all be able to reclaim our lives and do the things again that we love to do with the people that we love doing them with. So good luck to everyone.
Amen to that. All righty. Well, again, you've been listening to The Attorney Post. You can visit us online at theattorneypost.com. You can also visit Kevin's law firm at nortonrosefulbright.com, all spelled out. We'll have a link down below the show as well. That being said, I'm your host, Justin West. I've been talking with Kevin, and I wish you all the best. Until the next podcast, take care. Bye-bye.